The Taxpayers' Rights Advocate of the State Board of Equalization wants you to know you have rights. As a California taxpayer, your rights are protected during the assessment and collection of taxes, including the right to courteous and prompt service and the right to be treated fairly during all dealings with Board of Equalization employees and officers of the Board. Publication 70, Understanding Your Rights as a California Taxpayer, and Publication 145, California Taxpayer Advocates, can be useful in learning about your rights. If you feel the BOE has not resolved your concerns adequately, please contact the Taxpayers' Rights Advocates Office at 1-888-324-2798 or email us. The Taxpayers' Rights Advocate of the State Board of Equalization. We're here for you.
You asked, and we listened. Together, we've designed a California State Board of Equalization website with you in mind. The convenient login button allows you to access many of our online services from anywhere at any time. Drop-down menus make navigation easy. You can do everything from filing a return and making a payment to finding permits and licenses. Our interactive banners highlight the latest news, programs, and services. Popular topics help you find information quickly. The How Do I and Business Center sections offer you even more helpful resources, including individual tax guides for various industries. We also want to hear from you. Tell us, how was your experience? Your feedback is important because it helps us provide you with an improved and more interactive website. So check it out at boe.ca.gov. It's designed with you in mind.
It's easy to buy things online these days, but did you know you may need to pay tax on those items?
Really?
It's called use tax. And just like sales tax, the use tax you pay to California will help fund important services like public safety, healthcare, and schools. But how do you know if you owe use tax? When you buy things online, look to see if you were charged tax when you checked out. If you weren't, you may owe use tax. It's easy to figure out how little you may owe. For most purchases, you don't even have to save your receipts. Just use this convenient use tax table, available in your income tax instructions. Find your adjusted gross income to see how much you may owe, and enter that amount when preparing your state income taxes. It's that simple. No looking through files and no hassles. You've paid your use tax for the whole year.
That was easy.
Paying your use tax. Good for you. Good for California.
We're committed to supporting our communities, teaming up with businesses large and small, improving our roads and schools, investing in law enforcement and our environment. Together, we're funding a better quality of life. We're the California State Board of Equalization. The BOE was created in 1879 to equalize property tax assessment practices throughout California. Our responsibility has grown quite a bit since then. Today, the BOE administers more than 30 taxes and fees that provide 1/3 of all the revenue generated in our great state. And we're efficient. More than 99% of the money you contribute supports services and programs that benefit all of us in California. When you drive down our many highways, see a police officer helping someone in need, or enjoy a walk along a pristine beach, think about what makes it possible. Whether you're a business owner, making a purchase, or just filling up your gas tank, your contributions are important to our state's economic health. And the greatest part, we're doing it together. We're ready to work with you. Take advantage of our free seminars, helpful classes, instructional videos, and mobile applications. Also, use our online services. It's easy to do business with us from anywhere, at any time. Our partnership equals success. Learn more at boe.ca.gov. Together, we're supporting our communities and funding a better quality of life.
Members of the Board of Equalization want to hear from you. If you have ideas, concerns, or suggestions on how the board could improve services in the taxpayer experience, make sure to attend the annual Taxpayers Bill of Rights hearings in Culver City on April 26th or Sacramento on May 24th. If you'd like more information, visit boe.ca.gov.
Okay, good morning and guests, members and guests. Ms. Richmond, will you please call the roll to determine a quorum?
Chairwoman Ma.
Here.
Ms. Harkey. Here. Mr. Horton.
Here.
Mr. Runner.
Here.
Ms. Stowers.
Here. Thank you. A quorum is present. Ms. Richmond, please call our first item.
Good morning, Madam Chair and members. Our first item on today's agenda is item C, Sales and Use Tax Appeals Hearings. Our first hearing is C1, Richard Clark Farrell. Please come forward. Board Proceedings has received contribution disclosure forms for today's hearings from the parties, participants, and agents. All forms were properly completed and signed. No disqualifying contributions were disclosed. All parties, participants, and agents are on the alpha listings provided to your office. Each person sitting at the table will be asked to introduce themselves and, if necessary, their affiliation with the taxpayer for the record. 10 minutes is allocated for the taxpayer's opening presentation, followed by 10 minutes for the department's presentation, and 5 minutes is allocated for rebuttal. Ms. Ma.
Thank you, Ms. Richmond. Mr. Angija, will you please introduce the issues in the case?
Good morning, Chairwoman Ma and members. I'm Jeff Angija on behalf of the Appeals Division. The appeal before you presents one unresolved issue, which is whether petitioner is personally liable for the unpaid liabilities of Irvine Photographics pursuant to Revenue and Taxation Code Section 6829. And I would like to remind the board that this matter is subject to Section 40 and will require a published decision.
Okay. Thank you, Mr. Farrell. You have 10 minutes to make your initial presentation, and we'll have an additional 5 minutes on rebuttal. If you can please introduce yourself for the record.
My name is Richard Farrell. Is this
Just
work?
maybe pull it a little closer.
My name is
Yeah.
my name is Richard Farrell, and the first thing I would like to do is ask if it's appropriate. I really don't know, but I would ask to see if I could have an extension for this hearing. The reason is that I have been in bankruptcy since early 2014, and the federal trustee has not allowed me to have or spend any of my funds for an attorney for this case. And I would very much appreciate having an attorney represent me, because I don't know too much of what I'm doing. But
Okay. Mr. Angija?
I know that this has been extended. I believe this is the 5th request for an extension. It's within the discretion of the board to grant an extension or a deferral.
that's not
postponement.
correct.
Either the 4th or the 5th. I don't have
It's
the evidence in front of me. It's the discretion of the board to grant if they'd like. I don't want to get into bankruptcy issues this early, but I do know that the alleged conversion to a Chapter 7 is contested by the current trustee. And nothing in the bankruptcy court stops this proceeding, because this is an administrative proceeding that this board is able to decide, and without regard to the bankruptcy.
Okay, Mr. Farrell?
Yes, he is absolutely inaccurate. I don't know where he gets his information. However, number one, this is the 3rd appeal, and one took place because I moved and the information did not get to my residence. As far as his information, I don't know where he gets this, but the Chapter 7 conversion is absolutely not contested by the trustee nor by the creditors committee. He really, if he's going to make statements like that, I think he should really be accurate about them.
Okay,
and
so
this is on record, and I didn't bring it with me, but it is absolutely correct. About a week and a half ago, the trustee said she would not contest the matter, and about a week ago, the creditors committee said they would follow the trustee's recommendation.
Okay. Members?
I have a question.
Ms. Harkey?
If this goes to Chapter 7, how does that change your circumstance, other than you have representation and there are funds after the Chapter 7 to pay for representation?
Yes, ma'am. My funds are not, I cannot spend my funds. It's on a budget. And I've requested, but have not been allowed, to spend funds for an attorney for this matter. And after Chapter 7, the conversion, my understanding is, well, then I become somewhat, I don't know the right word, the legal words for it, but then I am no longer under the control of the trustee, and I'm able to actually spend money for an attorney, because I don't have to ask permission for that.
Yeah, I understand the way it all works.
I'm sorry, I don't
and
totally.
No, that's okay. I just wanted to hear you say it for the record. I do know that your funds are restricted. I do know you are on the budget. And I do know that the trustee always wants to be sure they get paid first, right off the top. So that's why I asked you specifically, are you going to have anything left? You've got secured creditors. So it's just IPG. There's no personal, they're not wrapping you personally into the bankruptcy?
Yes, they are. However, I have a reasonable salary, and I can spend monies from that. And I do have some monies that they've withheld that they have to give back to me.
Okay, thank you.
Mr. Renner.
Yeah, just a couple quick some thoughts and questions here. What do you believe the timetable will be?
I'm sorry for the.
What do you believe the timetable will be in regards to a delay for you enable you to have representation?
It was going to be the today, the 27th.
Okay.
It was going to have a hearing. However, the attorney for the creditors committee got married, and he's on a honeymoon, and so everyone agreed to postpone the hearing until the 2nd of May, which is next week. And that's when, and it's not contested, so it's expected that without any contesting, it should be approved.
We have a hearing when in Orange County?
Yes.
Orange County in July.
I'm sorry.
We have
Mr.
a hearing.
Renner,
We have a hearing in Orange County in July.
Oh, I'm sorry, sir. I was speaking of the federal bankruptcy.
No, that was my question, but I'm also was just thinking out our schedule.
Oh, I don't know. I don't know that. I'm sorry.
You know, I wasn't predisposed to allow an extension on this, but after hearing this, I kind of understand the bind that this gentleman is in, and I do know about the restrictions. I would be willing to postpone it till the July Orange County hearing, and I would make a motion to do so if the board would like to do so.
Do we need an action, or can we just?
Madam Chair.
Mr. Horton.
I was just wondering what our procedure would be real quick.
I don't believe it takes a vote to do this. The chairperson has the discretion to put it over, and we can put it over to July.
Okay.
I just don't think it changes the situation for the department at all by putting it over till July. And but I do think it allows the taxpayer a chance to perhaps get his affairs in order through the bankruptcy court. That's always questionable. But at least we would have a date certain in July that he either would or would not have counsel.
Okay.
It is fraud. So.
Mr. Horton.
I would concur, but I would like to hear, Madam Chair, from the department as to their perspective, and then of the appellant, only because you put it on record, otherwise I wouldn't be asking. What is your salary that you receive?
I receive $14,000 a month.
Okay. And of the department, what is your perspective of postponing this to July?
When our litigation division was asked about a postponement earlier this month, our response was that even if it's converted to a Chapter 7, there will still be a trustee in place to control the assets of the estate, so he won't be entirely in charge of his own finances. So our position when the request came in was to go forward with the case here.
Excuse me, though. I'd like to just comment on that.
Ms. Harkey.
If it's the bankruptcy is the company, this is a duel against him personally, and I'm not so sure that we can tie those two things together because we're going after him personally here. We're not going after the corporation.
The bankruptcy filings that we have are for Richard Clark Farrell, debtor and debtor in possession. So.
Right. But if the one part gets settled, and then there's just him, and he's allowed to take a salary out of the bankruptcy. I'm not sure. These things tend to go in big circles, and I'm not sure that you're not correct that it'll probably won't be any different. It may or may not. But I think waiting till July to allow him at least the opportunity is probably wise. I don't think it changes the department's case.
No.
It would be the same.
Correct.
So it might allow him representation.
Okay, so let's postpone your case, Mr. Farrell, till the July meeting. Ms. Richmond, can you announce for the record where and when?
It will be July 14th in Irvine,
July 14th in Irvine, starting at 9 a.m.
and we'll send you another hearing notice.
With the address?
Yes.
It's at the Irvine Council Chambers, City Council Chambers, Civic Center.
Well, thank you, Ms. Harkey. Thank you,
Okay.
ladies and gentlemen.
All right.
Appreciate it.
Thank you very much for coming. Okay. Ms. Richmond, next item?
So our next item, C2, has not checked in yet.
Okay.
Item C5, there's a waived appearance. Item D1 has checked in, but we are still waiting for the interpreter. So,
Okay. What else do we have? Can we continue to move on with the agenda?
Madam
Is there
Chair,
anything else?
no, there is nothing else.
We did everything.
You're so efficient yesterday.
Madam Chair,
Mr. Horton.
with your permission, we can take up C5, the waived appearance.
Waived appearance, yeah, we can take a vote on that.
Okay, let's do that.
I have a,
Mr. Renner?
well, I think,
We've got a revised recommendation for that case as well,
oh,
based on this is for Durman, C5.
Yes.
The department has accepted the taxpayers' numbers regarding the amount per sale and average customers per day, which reduces the tax from initially determined amount of $121,739.56 down to $29,737, and the penalty drops to $2,973.70.
Good deal.
this was.
And
C-
taxpayer agrees.
Okay.
Madam Chair,
Mr. Horton?
Good.
is it taxpayer agrees?
Yes.
That's a good thing.
Yes, he does.
We need, Ms. Richmond, maybe introduce it?
Oh, if you can introduce the item, C5, Ms. Richmond, so we can,
So the item we're taking up next is C5 Durman,
Yes.
Inc., which is a waived appearance.
okay. Mr. Njija just announced the revised recommendation.
So do we move to deny the petition based on the revised recommendation?
Or adopt staff's recommendation, I believe,
Move to adopt staff recommendation as amended,
as revised.
as revised.
Second.
Okay. There's a motion by Mr. Horton, a second by Ms. Harkey to.
I have a quick comment.
Oh, okay. Do you want to?
No, just a quick comment before we take a vote.
Okay. Mr. Renner.
I appreciate staff's looking at this. There was an issue of concern for me, and that the liability was based upon 1 hour observations, and so I was concerned about where that we actually ended up with that. So, I think that we've actually set in place better guidelines for observations now, so that we wouldn't be confronted with this kind of issue again. So, I appreciate the fact that there was a look at that. Thank you.
Thank you, staff.
Okay.
Well,
Any more comments, Mr. Horton?
yes. Members, I think it's wise that we also consider when the taxpayer doesn't provide any books and records, and then they fail to do an examination themselves to support their position, and then they fail to provide the department access to the information, books and records. Oftentimes, the department is left with no other alternative, and it's not the fault of the department that the test is always limited,
No,
as it is in this case, although I do appreciate an adjustment in the favor of the taxpayer. Given the judicial concerns relative to estimates and having to deal with all that stuff.
Okay. Ms. Harkey?
Yeah, I think we're going to be seeing a lot more of this, so the sooner we get some procedures in place, especially with this account, the better. We are going to have issues with lack of books and records, and I think we're trying to work on that to ensure that we do get some books and records on certain industries that tend not to have, not to be keeping them. And I think, like we said yesterday, we had with our scope program in licensing and whatnot, that we would, this might be another avenue to ensure that we put into into place a mechanism to verify and to ensure that we do have some books and records, such as kiosks and other things in these types of industries.
Yeah, this is an issue we've been working on, the fact that this industry does not have access to banking like other industries. We are looking at, kiosks, faster cash counters, but there are banks coming forward now proposing solutions or the ability to bank. So I think that's hopefully in the future, and we will have some verifiable third-party books and records. So I appreciate everybody's comments. Okay, without further delay, Mr. Horton moved, Ms. Harkey seconded to accept staff's revised recommendation. Without objection, motion carries. Ms. Richmond?
So item C2 has just shown up and signed in.
Okay.
So our next case is C2, Rodney L. Odom. Please come forward.
Thank you.
Okay. Mr. Anjija, please introduce the issues in the case.
Chairwoman Ma and members, the appeal before you presents 3 unresolved issues, which are whether claimant owes use tax on the difference between the actual vehicle purchase price and the reported purchase price, whether relief of the finality penalty is warranted, and whether additional relief of interest is warranted. And the department has a revised recommendation for this case as well. In addition to the interest that's already been relieved, they now have revised a recommendation to relieve interest for the additional period of October 1, 2008 through May 31st of 2010. And I don't have numbers, but that's the period for which interest would be relieved, in addition to what's already been recommended.
So how much are we talking about right now?
The relief for the first 2 periods of interest was $270.19, and we're talking an additional year and a half, 18 months worth of interest. I don't have a number off the top. This was just last night, so I don't have a number for you. I'm sorry. Perhaps the department's got a number.
Department have a number?
Department?
Yes. Ms. Ma, we
Mr.
don't have a number that relates to that, but we did look at the case from the standpoint of when our cut section had received information that identified the difference in values that are in question today. And it was reasonable in our minds to have processed that information within 6 months' time from the time that we received the data download from DMV, had that information processed by our technology services department, and then supplied to our cuts section. And so we allowed 6 months for us to perform that work. But in this case, there were additional delays that we felt were on the department. So that's why we're recommending an additional 6-month relief of interest.
Okay, so the calculations we have are already net of interest, I believe. So we were showing tax due of $581.83 and a penalty of $143.50. Is that what we're discussing today?
Yes. Correct.
No.
No.
There was a
Proposed tax is $1435. The balance due is the $581.83.
Oh, okay. But the interest is already net. That $270 is net.
Yes, and we'll go further down with the result of this new revised recommendation.
Okay.
But we don't know how much.
Right, sorry.
Okay. All right, so Mr. Odom, welcome to the State Board of Equalization. You have 10 minutes to present your case, and you will have an additional 5 minutes on rebuttal. Please introduce yourself for the record. And
my name is Rodney Odom, and I am here in regards to the additional taxes that the Board of Equalization is asserting to me. That's the reason why I'm here. I think we all can agree that if there was no additional taxes appropriate, that these penalties are irrelevant. So therefore, I would like to proceed with first clarifying if indeed additional taxes was due or not. So as I begin to communicate with the Board of Equalization, they first contacted me around, they first was informed themselves on 5/12 of 07 that the purchase price and the taxes paid upon registration was different. So when I spoke to the when I spoke to the Board of Equalization, April 2nd, 2010, by way of letter, they sent me a letter. However, I did not personally speak to BOE until August 18th, 2010, in regards to this issue. And they admit that themselves on page 5, line 16, that the first time that they communicated with me verbally was August 18th, 2010. At that time, I told the representative I was a dealer and did not owe taxes because of my dealer's license. So when the representative called me saying that I owe these taxes, my response was, as a dealer, I don't pay taxes. The taxes are deferred to the customer. I had no idea of what vehicle they was talking about. I had no idea what the issue was. So the representative told me, okay, they would check and make sure that I was a dealer at that time and get back with me. I did not get a response from the BOE until September 14th, 2011, where I was told on that date I owed additional taxes. I requested to speak with the supervisor because I didn't feel I owed any additional taxes. So the the Board of Equalization contends that a supervisor called me the following day and left a message. However, I did not speak to them. So I called the BOE on October 11, 2011. I called the BOE, spoke to a representative, explained I was expecting to speak with a supervisor, and representative said, let her investigate and get back to me. Still no reply. November 22nd, 2013 to May 30th, 2014. I called 13 times requesting to speak with the supervisor to clarify how these taxes was being asserted and if indeed I did owe them, and just to find out what was going on. I still was not given the opportunity to speak with the supervisor. So here on April 1st, 2014, I was so livid with this situation that I got in my car and I drove over to Irvine and requested to speak with a supervisor there. The representative there checked the case and said it was not from their department, and she directed me to go to Norwalk. So right away I drove from there to Norwalk. At that point I was able to speak with a supervisor, or a lady that represented herself as a supervisor, named Erin Little. At that time, Erin Little said that I did indeed owe the taxes. She used a regulation 16669.5. She had me read it, and that section does indicate that if I purchase a vehicle as a dealer and at some point take that vehicle out of dealer inventory and register it to myself, that indeed I need to pay taxes on the original purchase amount. So she clarified it and said if I still did not agree, that I could pay the tax portion and file for an appeal, which I did. I paid the tax portion. I immediately filed for an appeal in writing that was mailed to her by April 14th, 2014. However, I did not get my appeals hearing until March 25th, 2015, which was just under a year later. As we proceeded in that hearing, immediately the tax counselor, Dan Nugent or something like that, immediately identified that section regulation 16669.5 did not apply to me because at the time that I registered the vehicle, I was not a dealer at that time. So he gave the Board of Equalization, Rhonda Esser, 15 days to reappropriate the assertion of the taxes. She did. She came back on August 8th, and then she applied the taxes under Section 1610C1. And she contended that that was the new regulation that they was asserting the taxes on. And so I read that section, and it does indicate that taxes was due, in which taxes was paid, but that section does not indicate that taxes are due on the original purchase amount. So again, I didn't feel like the Board of Equalization was asserting this additional taxes to me in a correct manner in which that I could understand. So as we come here today, and I'm looking at the report that the Board of Equalization has presented to the board, they're asserting these taxes even under a different section today, which is Section 6244, Regulation 1669, and they're eliminating the 0.5. So it seems that the department is changing the regulation as this goes along. Meanwhile, they've had a lien filed against myself and my property for over 4 years. It has taken over 4 years for us to come to a resolution on this issue. In my opinion, the BOE has definitely abused their power by not removing the lien after they received their full tax portion of the amount that they contended that I owed. And I explained to them that I needed a good credit report so that I could continue to do business with my vendors, because a lot of them deal with me based on my credit report, and that by them keeping this lien on my credit, it was preventing me from taking care of my family and doing business. They still said they could not do anything to help in this situation. And here today, I'm still confused as to how the BOE is asserting these taxes, because they have been inconsistent and they have changed now 3 times. At the appeals hearing, the counselor gave 15 days to reassert the taxes. That would have been April 9th, 2015. So any new assertion after April 9th, 2016 is not in a timely manner, because it was to my understanding that they only had 15 days to assert the proper regulation. That regulation was 1610 at that time, and they're presenting to the board today Section 6244 and Regulation 1669. So again, you see an inconsistency in the way the BOE is representing this additional taxes that they're contending that I owe. I still stand before you today saying that I never owed these taxes from the beginning. And in trying to clarify if I owe these taxes or not, the BOE has never been consistently clear as to how I owe these taxes. And so I move for the board to challenge the department, the Board of Equalization, to be consistent and to communicate with the clients in a timely manner, and to allow the clients to speak with the supervisor when they can't get clarification from the representatives. Throughout this process, I've drove to the Board of Equalization in Irvine. I've also drove to Norwalk. I've also went to headquarters in Sacramento to meet with Brian Fikes in regards to this matter. So I've done everything humanly possible to work with the Board of Equalization by way of calling, driving, staying in communication with them, and they've been consistent with, we're going to leave this on your credit report, and we're going to leave this lien against you, and we're in no hurry to resolve this issue. Again, I feel that that's an abuse of power, and no one should have this kind of power to destroy a man's life in this matter.
Thank you, Mr. Odom. To the department, you will have 10 minutes to make your presentation.
Good morning, Chairwoman Ma and members of the board. I'm Kevin Smith from the board's legal department. With me today are Robert Tucker, also from the legal department, and Kevin Hakes from the business, tax, and fee department. We will be representing staff. We agree with the appeals division recommendation. At issue here today is the measure of tax on a vehicle claimant withdrew from resale inventory for personal use. Claimant operated a used car dealership in the city of Highland as a sole proprietorship. On May 12, 2007, claimant purchased the vehicle at issue today for resale for a purchase price of $26,500. Subsequently, claimant went out of business and his seller's permit was closed effective September 30th, 2007. On March 20th, 2008, claimant registered the vehicle in his own name with the Department of Motor Vehicles and paid tax on a claimed purchase price of $7,999. Under Revenue and Taxation Code Section 6244, if a person who purchases property for the purpose of reselling it makes any use of the property other than retention, demonstration, or display while holding it for sale in the regular course of business, that use is taxable. And the measure of the tax is the purchase price of the property. Here, claimant purchased the vehicle at issue for resale and did not resell the car. Instead, the car was withdrawn from resale inventory and on March 20th, 2008, registered in claimant's own name. Therefore, the proper measure of tax is the purchase price of the property, $26,500. Accordingly, we agree with the appeals division recommendation. Thank you.
Okay, thank you. Mr. Odom, you have 5 minutes on rebuttal.
Again, the section that the department is representing today should have been represented in the response, the 15 days response by Rhonda Esser, who only had 15 days to respond to this matter in the proper way. At that time, you'll notice on exhibit you'll see her letter. I don't know if you guys have exhibits, but I'll show it to you. It's dated August 8th.
Can we get a copy of that?
These were submitted to the department, so you guys should have copies. Should I continue?
Sure.
Or
You're going to reference a document if you can just wait.
Okay, thank you. I'm sorry, board. This is actually the part of the document that she took. So if I could just pass this to you guys, perhaps you guys can take a look at it because this is the relevant document.
Ms. Richmond?
Do we have it?
An extra copy of the whole thing.
for the sake of time, perhaps the Board of Equalization might consent that the response letter was Rhonda Esser reasserted the taxes under section 1610C1.
And that's the letter you're referencing, right? Yeah,
Yes.
we'd like to see that.
Okay, thank you.
Thank you. Yes. Thank you. It's on page 2. The reassertion. Page 2, Fiona, is the reassertion.
So you'll notice on page 2, right under the bold writing is where the tax counselor is asking the department to clarify these taxes. And he's saying that, and her response is directly under there, where the new assertion is sales tax. It says California is subject to use tax, sales, and regulation tax. Regulation 1610C1 states as follows. So that was the new assertion that she was applying to this matter. And my contention all along was that that section did indicate that taxes was due at the point of registering the vehicle. And I did pay taxes on what I thought was the fair market value of the vehicle. And one more thing I'd like to point out, the department keeps indicating that I removed the vehicle from dealer inventory, but at the time that I registered the vehicle, I was not a dealer anymore. And I was forced out of my business, so therefore I was just trying to do the proper thing by registering the vehicle in my personal name, as I decided that I would keep it. I couldn't sell it. The vehicle was mislabeled. It was not the vehicle that I thought I had purchased, because I had purchased it for a client that had found the vehicle himself. He did purchase the vehicle. However, his check from Capital One did not clear, so I had to go repossess the vehicle from this client and take it back into inventory. So that's how I ended up with this vehicle from the beginning. So again, the BOE has not been clear as to how they're asserting these taxes, and they're continuing to change their assertion along the way.
Okay, members. Mr. Horton.
Sure. Again, my apologies, my voice is gone, but so when I pause, it's just trying to get it back again. Question of the department, given the nominal amount of the interest, is there a reason that, and a couple of things, given the nominal amount of interest and the appearance that the taxpayer appears to be very cooperative in trying to resolve this matter, is there a reason the lien wasn't removed?
Mr. Renner,
that's pretty good.
I mean, excuse me. Mr. Horner, thank you.
Brothers from another
mother. Looking one way and talking in a different direction.
I was thinking the same question.
Right. Members, it does appear as though the petitioner was cooperative. Now, I note that there was a collection cost recovery fee that applied in this instance too. So there were difficulties actually in collecting the amounts that are in question. Liens were or levies were issued to collect the amounts that were owed. Certainly we try and give taxpayers the most opportunity to enter into installment payment agreements if they're unable to pay the amounts that are owed to us. So only anticipate from the record that there was some difficulty in the taxpayer talking to our compliance staff regarding payments, and that's why
when did that difficulty
that's
occur?
why collection action was taken.
Apologies. When did that difficulty occur, before or after he paid the bill, taxes?
That occurred before, right? Before, that's correct.
So that's a condition precedent. After he paid the taxes, why not just release the lien?
I believe that there were certain amounts that were still remaining.
It was
the disputed amount.
But I agree with you. I mean, those amounts are very small. So I believe we should have taken action to do that.
Let me encourage the department. We have to make decisions based on larger issues relative to the taxpayer. When we have a situation where the taxpayer is cooperative, our objective should be twofold. Not only to protect the interests of the state of California in collecting the tax relative to our fiduciary responsibilities, we also should be doing what we can to make sure that the taxpayer is in a position to ultimately pay the liability. And liens have a tendency to inhibit that ability. And we just need to be conscious of that, I think, at a larger level. Another question, and this goes to maybe, I'm sort of thinking out loud, but looking at 6596 relief. When did, I don't remember the time frames, maybe it was after. When did the appellant meet with the department and received advice on why the liability might be due, and at what point was the liability actually assessed? Based on his testimony, it appears that there was some confusion among the different representatives of the board and as to whether or not an NOD, those determination was it should be issued and under what conditions should it be issued. Can you bring some clarity to that?
Well, Mr. Horton, I was just going to clarify regarding the liens. I know it's a policy of the department not to release liens until the full liability is paid. So I just wanted to clarify that. Now, in this case, I see that there's about a $600 amount remaining balance on the account, and that's why that lien hasn't been released. So just to clarify that point, but obviously a relatively small amount.
If I may speak to that, I appreciate the policy.
Mm-hmm.
I appreciate the policy, and I believe the policy is in place when we have an exposure. All of our policies are sort of based upon our perception of our fiduciary responsibility and risk. And a subjective analysis should be able to be made at a point prior to this body. And I just would encourage supervisors to take that under consideration when we have a situation where the taxpayer is fully cooperative, minimum risk to the state of California, and is an impediment to their operation. You know, it's like It's like taking a driver's license away from a bus driver. Why would you do that? Can't operate because he ain't paid the ticket.
Right. Appreciate that comment, and we'll certainly communicate that.
To the original question.
But your original question, it was actually the consumer use tax section that evaluated the case back in May of 2010, and it was their determination that given the variance in the declared value of the vehicle of $79.99 versus the stated selling price of $26,500, that established the differential that the consumer use tax section needed to support why the notice of determination was necessary, given that delta between those valuations. And it was later in 2015 that the case was subsequently transferred into a claim for refund case because the taxpayer had paid the associated tax related to that notice of determination. And our refund section incorrectly referenced 1610 as being the applicable statute that dealt with this situation, when in fact it's really 6244, section 6244, that relates to the taxability of the purchase. So I think there was an incorrect reference to why the determination was made. But previously our consumer use tax section had explained to the taxpayer why the billing was issued and the rationale for that billing.
Let me restate, unless someone else is going to get to the question.
Yes. More directly, the NOD was first issued. On the NOD, it explained that the total amount of the NOD, it represents the difference between the purchase price of $26,500 and the amounts that were reported to DMV.
When was that issued?
It was issued on
May 6, 2010.
Yes, and that was done before. So
when was the initial meeting with the? Maybe I should ask the appellant.
Yes.
Please.
When was your initial meeting with the anyone from the agency who gave you advice as to the taxability of this transaction?
Again, as I articulated, I was not able to speak with anyone to clarify how these taxes was being asserted until I drove to the Norwalk.
You drove to Irvine.
I drove to Irvine, and they sent me straight to Norwalk, where I spoke with Erin Little, and she was able to show me the section, have me read it, and on that date, she gave me this letter where we went into agreement that if I pay the outstanding taxes, that would position me for appeal, and that in the appeal process, I would have an opportunity to discuss with the department as to why I felt that the amount that I reported to the DMV was appropriate, because I did understand that there was a difference in the purchase price and the value that I registered the vehicle under. But I did not understand how the Board of Equalization could tell me how much I could sell that car to myself for.
Okay, so you just introduced some new evidence. I'll take it and run with it. So it sounds as if, though, the advice was given after the
Correct.
NOD.
Yes.
Okay. Question of the department. Were you able to verify that the car was originally sold, repossessed?
we were not able to do so.
He didn't. He hasn't provided any documentation showing that.
They didn't ask for any documentation.
Sir, I
I'm sorry.
apologize, but I'm going to ask if I can respond. When you sold the vehicle, how much did you sell it for?
I sold the vehicle initially for $28,000.
$28,000, and then you repossessed the vehicle?
Yes, it was forced back into my inventory because the check that was submitted did not clear, and therefore I had to go get the vehicle back because I didn't.
So you repossessed it?
Yes.
Okay. How much of loss did you take in repossessing the vehicle?
I'd say at that point I probably lost somewhere around $1,000.
Okay. What do you think the value of the car was when you brought it back into inventory?
When I brought the car back into inventory and really assessed the vehicle because it was mislabeled and so on and so forth, the value of the vehicle at that time was probably around $12,000, $13,000.
$12,000, $13,000. Okay, that makes sense. And then you indicated that you sold the vehicle to yourself?
Yes, after a year later, I was out of business.
It was a year later?
Yeah.
Okay.
The car was still in my inventory. It had been in an accident.
Question of the department, I got you.
Yeah.
Had been in an accident when you sold it?
Yeah, when
When
the
you
car
bought it back? Okay,
Yeah, I had
that's good
let
news.
a client test drive it, and they got in an accident, so that
Question
took
of
some
the-
value away from it as well.
Question of the department. Have you been able to verify this?
No, and the one complication we have is that the mileage at the time of his purchase and the time of registration with DMV was the exact same.
Exact same mileage?
Yes.
Question of the appellant. Any reason? How can that be?
How can that be?
He reports the
Somebody got
mileage.
test drive a car.
He reports the mileage.
Oh, question of the appellant. Did you make a mistake?
It sounds like to me it could have been an oversight from the time that I sold the vehicle to the first person and took it back in the inventory, and then when I registered to myself, maybe that information was not changed.
Okay. When you say you sold it to yourself, what documents do you have to support that?
Well, the only documents I would have is a document that actually the BOE presented in their package, and it has the date that I transferred the vehicle from dealer inventory to myself.
Yeah.
So and again, that was a year later, and it was at a point where I was out of business, and I was actually stuck and forced to do something with the vehicle. So I thought the appropriate thing would do was what I did.
Okay. So this car, before he took it out of inventory, sounds as if there was a lot of activity there, and possibly the department needs to have an opportunity to verify that activity that occurred. One good question. Did you share all this with the department, or is this all new to the department?
Absolutely. I shared all this with the department, and what I found to be very interesting is that when I communicated this information to the department early in 2010, when all the documentation was readily available, they didn't request it. But then now way in 2014, after the statute of limitation passes to where I have to keep these documents in my possession, then they ask for the information. So
Question of the department, any evidence that the taxpayer appellant has made these, I don't want to call them statements in the process?
It's in their report.
They were in the DNR.
I thought they were. Yeah. And why wasn't they examined by the department or considered?
I think because the issue here is that the purchase price is what tax is due on. The fair market value of the vehicle at the time you registered it is not what's relevant. What's important is the purchase price under 6244.
You're not understanding the question. I think the law is, I think in another section of the law you got to look at. I'll pull it up in a minute. Brain working a little slow too. So, as I understand the testimony, you got a dealer. Is he a dealer at this time?
At this time?
No, at the time.
At the time.
Could he sell a car?
At the time he purchased it for resale, he was a dealer.
Okay.
By the time he registered it, he was
If a dealer sells a car, it's sold, then the dealer repossesses the car, and then he takes it out of inventory. What's the measure of tax?
It would still be the purchase price. And again, there's no evidence here that he's ever provided that shows that he sold it or that
okay, Mr.
there's a change in ownership.
I don't want to interrupt you, sir. My apologies. I got very little voice. Mr. Njija?
Essentially, you can't sell to yourself what you already
No.
own.
Let me restate. His testimony is he sold the car to another party and then had to repossess the car. And then he held it for a year to resell, and then pulled it out of inventory for his personal use.
A repossession is not a repurchase. It's essentially an unwind. Had he reported that transaction as taxable, the repossession would give him a bad debt deduction.
Right.
Doesn't change his initial cost of that vehicle. It just unwinds the alleged sale, pulls it back into inventory. Still, his cost is the $25,000 or $26,000, and then when he subsequently withdraws it, even a year later, he owned it. Our understanding of the case and what the department's trying to say is he owned it at all times. You can't sell to yourself what you already own.
No, I understand that. Well, that sounds a little...
And we held the appeals conference. There's no evidence, documentary evidence. I understand the testimony, and I'm not trying to argue, but we've got no evidence of a sale and then repurchase. And even if there were, it doesn't change.
Let me go back to the department. My apologies, members. I can kind of chill if you wanted to. I didn't hear the departments testify that they even looked at it. When you say there's no evidence, the appellate made a statement and that the car was sold and then subsequently repossessed. And did we look at it?
Those
Did
documents.
we ask for the documents?
Yeah, those documents. I mean, I believe in the DNR it states that those documents were requested of the taxpayer. We'll claim it here, and we're not provided.
Appellate, why didn't you provide the documents?
Again, the only reason why I didn't provide the documents is that at the time that the department requested them, I didn't have them. And my contention...
Do you have any of them now? That shows you sold the car?
Well...
And repossessed it?
If you noted, I was going to bring in the person that I sold it to, and so that he can give a testimony here today. But as I reviewed this matter, I had come to the conclusion that, you know, if the BOE cannot properly assert the taxes in a proper way and is inconsistent all along with how they're asserting these taxes, and now they're asserting a different section today that has never been asserted before. After looking at that, my thought was, I'm going to be wasting the board's time talking about selling the car, bringing it back, and so on and so forth, because the issue of the matter here is, if I did indeed owe the taxes, then tell me the regulation that I owe them. At the point that Aaron Little, a supervisor, showed me the regulation, had me read it, I agreed to pay, and I applied for appeal based on, I know regulations are put in place for specific reasons, but every now and then you run into a situation that needs to be talked out and adjusted. So I thought that would be just one of these situations. So I paid the additional taxes, requesting an appeal right away.
Yeah, I'm sure my brother will deal with that. He, Mr. Runner. But it sounds like the department is without that evidence or evidence of an actual sale, and without evidence that the transaction was ever reported. They're treating it basically as an unwind, which is different than if you sold it and then actually brought it back into inventory after a sale, reporting the taxes, taking your loss, and all that other stuff. Then there may be some adjustment to the value of the car. Last question of the department. Any evidence to the accident that occurred?
No, there's no evidence. And I also wanted to point out that we have a certificate of title here, which shows the only signatures on the title are the signature of the seller who sold the car to him, and then his signature when he registered the car in his own name. So there's no evidence of an intervening transfer.
Transfer or transaction.
Or transaction.
Okay. All right. Thank you, Madam Chair. Appreciate it.
Okay. Thank you, Mr. Runner.
Just a couple of quick observations. One is, obviously we have a dispute of facts that is in the midst of here, but I guess my greater concern, quite frankly, is some procedural issues. Number one, I'm concerned about a reasonableness test when we put a lien on for this amount of money. I just doesn't, it just, again, that just seems like effort and cost there, and then the effect on taxpayer is just a bit extreme. The other issue I'm just trying to figure out, and that is, and to me, this is maybe one of those examples of the difference of what happens when an item is resolved or tried to resolve at a district level versus a headquarters level. I'm especially concerned about the fact that a taxpayer went to where I thought he would think the normal resolution to his issue would be.
Absolutely.
His Irvine BOE office, and then gets directed to Norwalk, again, not because of the Norwalk district office, but to the Norwalk headquarters office. I just think, Dan, that to a taxpayer and to an average person looking at that, they don't understand why it is that they're being directed around like that. Let me just ask, why couldn't something like this be transferred back and get resolved at the district level, in terms of trying to solve this problem for a taxpayer and collect the money for the state of California?
Right. Well, I think the collection activity did occur out in the field, and so the communication that the taxpayer is talking about did happen out in the field. Now, the origination of the billing, though, that information is actually looked at and processed by the consumer use tax section within headquarters.
Who put the lien on? Who put the lien on?
So that would have been our compliance staff.
Headquarters.
I don't know if it would have been headquarters or out in the field. It could have been centralized collection. So
you can't
headquarters,
tell who put it on?
Headquarters or I don't know. It would have been our centralized collection group. So I don't know if that originated out in headquarters.
So centralized
or in
collection
the field.
put the lien on?
Correct.
Okay, that's a headquarters operation, correct?
We have a presence of collectors in other offices, so I don't know if that originated at headquarters.
Okay, hold
or
on.
out in the
Let's
field.
back up a little bit. We have a presence of collectors in district offices, right? But aren't those collectors, aren't those compliance folks actually then assigned to the district office? We don't have headquarters collection folks assigned to district offices, do we?
They requested it, but they wouldn't have processed it. Right. So it's likely that would have been handled by headquarters, probably our centralized collection section.
Okay. That to me, I think makes sense, which is, again, I'm struggling why it is then those kind of decisions aren't better made at a district office level and a collection based upon knowing the taxpayer, dealing with the taxpayer, and having taxpayers not having to run around all over Southern California to get an answer. So procedurally wise, I'm just struggling with this as a process, and I think it's one of those issues that we need to again review to see whether or not some of these processes and procedures are best handled at a district office in order to resolve concerns and issues with taxpayers. Again, the other issue is a reasonableness test, and that is, I'm hoping there's not a lot of places where we're putting liens on $500 tax obligations.
Originally, of course, it was more than that, but I agree.
But it was not removed when it got
it's not
down to
large.
that amount.
Correct. The policy is not to remove it until the amount in question has been paid in full.
Yeah. Okay. Again, the facts are, trying to get through the facts. The taxpayer has issues in regards to not necessarily having all the right documentation either, in regards to some of these discussions. And again, you take that plus the amount of time that all of us have spent right now on this $500. It seems to me that somewhere in the line there ought to be some common sense put into this to determine how do you get resolution, how do you keep all of our time better focused, we've spent the $500 just in the last 30 minutes here, so that's my concern.
May I share a point?
1 second. Ms. Harkey.
No, thank you. I'll just continue. I understand the issue. I have some questions for the taxpayer, for Mr. Odom. What type of car was this?
It was a 2002 CL500.
Okay, I have a Kelly Blue Book guide here, May-June 2002, that shows the CL500 Coupe two-door having a wholesale price of $38,100 and a suggested retail price of $45,300. I looked to 2008 Kelly Blue Book. I have a wholesale price of $26,800. How do you reconcile that?
Again, the vehicle was mislabeled, and it appeared to have all of the options of a CL600. And I don't know if you're familiar with the way Mercedes value their vehicles. The same vehicle, the same body style, but with just different equipment can change the price tremendously.
Yeah, well, that's why I asked you what kind of vehicle it was, and you said it was a CL500 coupe.
That is correct, and the vehicle was labeled as a CL600 with all the options, electric start, this and that, all the bells and whistles. So just to give you an example, a regular S500 would run somewhere probably around $80,000, $90,000 brand new. But this same vehicle in a 55 series would run somewhere close to $200,000. Same vehicle.
Right.
Just based on the options and the motor and so on and so forth. So as this vehicle was presented as one to have all the options, all the bells and whistles, and to find out consequently that it did not, that's what changed the value for me. And then after it was involved in an accident and I had it in my inventory for a year and no one was interested in buying the car, I thought I would have sold the car prior to putting it in my inventory. But no one wanted the vehicle. So my thought was if I'm going to drive the vehicle, I need to do the honest thing and register the vehicle so that I could drive it. So I thought I was within my rights to sell the vehicle to myself for $8,000, which is what I did.
Okay, well, I think, you've confused CL55 and CL500. They are two totally different cars. I know Mercedes very well. And so it's not that I don't, I drive them.
The example I gave you was of
Okay.
a 2016. But
Okay.
in the day we looking at, it would have been a CL500 versus a CL600.
Okay, well, I have a CL500 here, like I said, that's 26.8. That's wholesale. So let's say we could knock, I think that's about what you paid for it, right?
Exactly.
Okay. And then the next year, yeah, so in 2007, it was 38.1, but 26.8 in 2008. And you said it got into an accident. I think the bigger problem is all the changes in the regulations, like you have delineated. But I'm still having a little problem dropping the car from $26,000 to $8,000 at the time you decided to purchase it.
I really feel that would have been a legitimate conversation that the BOE and I could have had in regards to the value of the vehicle. But the BOE never introduced this conversation. They just was very consistent in steamrolling and saying that I owed the money without telling me the regulation that I owed it for. And I was going to share a second ago that even after going through all of this, I set up a meeting with Wayne Marciano and met with him in West Covina, California, as I thought that, okay, maybe we're just not getting to the right person. Maybe I'm not talking to a person at a high enough level to make a real decision here. So I went and met with him personally in West Covina, and still to no prevail. He just said that he was going to stay with the recommendation from the department. So
Okay, well, let me just, I think that this has been, a case has really been shifted depending on who's had so I'm with you on the regulation. Which one do you fall under? What I'm not with is the price of the value that you sold the car, but I do believe that even though the policy says liens aren't removed, there should be some flexibility there by the time you're going through the whole supervisory level. So I do plan on checking to see if our policies allow for some flexibility, because I know staff generally tries to do what they can do, and if there's a lien, they don't remove the lien till it's paid, and maybe that's something that we can work on in either our customer service or our right of reg in business taxes to allow some flexibility at the supervisory level before it gets to the board. So I'm with you on the amount, the jockeying around. I think that was truly, that's really unfortunate. Had this was a long time ago, I wish that it could have been handled by the district office. I agree with Mr. Runner. I think it would have been handled better. Once we get into headquarters, it's just like anything else. It's a big operation. They have a lot of issues, and you're just one of them. And our district offices tend to, we try as board members to emphasize that we are there to assist you when we can with the complexities of the laws and to help you to pay a fair and equitable tax, no more, no less. So I think I don't have really any questions. I just am, like I said, I am still trying to figure out what the proper, maybe the staff can help me. After hearing this testimony, what is the regulation? What is the regulation, and what does it state that we are really trying to enforce here?
It's 6244 is the statute, and the regulation that comes from the statute is 1669.
And tell me about it.
So the regulation states that essentially if somebody purchases something for resale, if the property is used for any other purpose, the purchaser must include in the measure of tax reported the purchase price of the property. That's what 1669 states.
Okay, and it doesn't allow that he was a dealer or not a dealer?
Right, correct.
Okay. And he says he was not a dealer at the time. You were not a dealer at the time you purchased the car for your own?
No, and the regulation that he's sharing does not stipulate that, because that's why they asserted 1669.5. Now he's taken off the 0.5 and he's trying to use the same regulation, and I don't know if that's...
Okay, department, I'm sorry.
Regulation 1669.5 and Regulation 1669 are both based on the same statute, which is Section 6244. So the legal basis is the same for both.
What's the difference between the 5 off and the 5 on?
The 5 on is addressed, I believe, for car dealerships.
Correct.
Correct. Yes.
And the 5 off is
for everyone else.
Anybody else that runs
But the rule is precisely the same.
Okay, but you still pay taxes on the amount of
the cost.
Of the cost of the car.
Correct.
Okay. Thank you.
Okay, I have a couple questions. So, Mr. Odom, so when did you register your car?
In 2008, at some point.
2008, with the DMV. When you sold your car, or sold that car to that owner, did you charge sales tax to the owner?
Absolutely, at the point of the original purchase, but when I unwind the deal, as they said, none of that was applicable. I mean, when you sell a vehicle, you have 10 days to report the information to the DMV, and I had the vehicle back in my inventory before the 10 days expired. So that is the explanation as to why the process never made it to the DMV level.
I see. Okay. So you never really collected because his check bounced, so you didn't really collect the sales tax, and so because within 10 days
all I did
you
was
repossessed
spend my money and never got it back.
Okay. And then in 2008, when you registered with the DMV, you registered based on the value you believed.
Yes, ma'am.
It was. Okay. And you used what type of methodology. I know that the car got into an accident, so obviously it's going to be discounted from the Kelly Blue Book value. And was it based on your professional experience, or how did you?
It was just based on my professional experience because I had two options at this point. I had a vehicle back in my inventory that I could not sell. So I could have took it to the auction and tried my luck there and just sold it for the value at that time. As I did my research, I didn't see that I was going to get much more than the $8,000 that I registered it for. So that's how I based my decision, whether to take it to the auction and try to just pass it on to the next dealer, or go ahead and register it myself. As I pondered this thought, I needed a driver at the time, so I decided to register the vehicle so that I could drive it legally. Now, had I still had my dealer's license, I never would have registered the vehicle because it just wouldn't have made sense.
Ms. Dowers?
Just one quick question to the department. You're saying 6244 requires when a purchase the property and then they put it into their own personal use, they have to pay tax based on the purchase price?
Correct.
Correct? And there's no change in that rule if they're no longer a dealer? It's still into the purchase price? Okay.
Correct.
Okay, I understand, Mr. Odom, what you're saying, that you couldn't sell a vehicle, you were no longer a dealer, you thought the $8,000 was a reasonable fair market value, but unfortunately, the way the statute is written, we cannot use that fair market value to lower the amount of sales tax that you have to pay. I do have an issue with the finality penalty. What the timeline is showing me is that the NOD was issued in May of 2010. The claimant did not speak to anyone until August 2010. And then throughout that process, there was a question within our own agency on what regulation we were using to impose the tax, so there was not clarity. So at this time, I'm willing to make a motion with the noted department concessions on all the interests to partially grant the appeal by also canceling the finality penalty.
Second.
For discussion?
Ms. Sarkey?
Okay, there was interest of 438. In essence, I've got a total interest and finality penalty of 581.83, right?
Right. Correct.
But the department's already corrected some of that, right?
Okay, the department's corrected some of that, and you want to get rid of 143.50, and we don't know how much has really been corrected. Would you accept a substitute motion to just relieve the interest and the finality penalty and call this a day and remove the lien?
I accept that substitute motion.
Okay, that's my motion.
I remove my second, Madam Chair.
Okay. So who is,
I make
Ms. Harkey,
a
Ms.
motion
Dowers?
to relieve the interest and relieve the finality penalty, a total of 581.83, and be sure that, and also remove the lien on the person's property.
Okay, so there's a motion on the table. Ms. Harkey motions to relieve the interest and the finality penalty and remove the lien from Mr. Odom's account. Ms. Dowers, second. Without objection, motion carries.
Madam Chair, if I
I
may.
think Mr. Anjija can explain what.
In regards to the additional taxes, you guys are saying that they were still indeed owed? Taxes on 26.5 versus the 8,000 that I paid taxes on?
Yes.
And I will get some information as to how to appeal this further.
Yes.
Thank you.
Okay, Ms. Richmond, next item.
Our next item is D, Special Taxes Appeals Hearing, D1. Our interpreter is not scheduled to arrive until 11 o'clock, so with your permission, I'd like to request a recess until that time.
Okay, we will be in recess until 11 o'clock.
What are we recessing for?
Okay. Okay, thank you. We are back from our short recess, and we're going to have Ms. Richmond call our last case for today.
So our last case for today is item D, Special Taxes Appeals Hearing, D1. Sahak Jeiranian, please come forward. And we do have an interpreter for this case. And it will not be simultaneous.
Right. Thank you. So if we could have Mr. Njija announce the issues.
Chairwoman Ma and members, the appeal before you presents 4 unresolved issues, which are whether taxpayer is liable for the tax at issue, whether the department has established fraud by clear and convincing evidence, whether relief of the failure to file and finality penalties is warranted, and whether relief of the collection cost recovery fee is warranted. And I would like to remind the board that this matter is subject to Section 40 as well and will require a published decision.
Okay. Thank you very much. To the taxpayers, if you can introduce yourself and also your interpreter.
My name is Sahak Jeiranian. I'm
The taxpayer?
yeah, I'm a taxpayer. Huh?
Okay.
And this is Tigran Kirakosian.
Give me your name.
Tigran Kirakosian.
Tigran
Yeah, Tigran Kirakosian.
Kirakosian. Okay. Okay, great. And you will have 10 minutes to make your initial presentation. And Ms. Richmond, do we give them extra time for interpretation as well? Yes. And then the BOE staff will make their presentation for 10 minutes, and then you will have 5 minutes after to rebut their interpretation. Okay.
If you allow to me to read, I read everything here.
Okay.
Wherever I read it, it's much better. You can read very fast to you guys.
Yes.
It's be much easy for you guys, very fast. So,
Can you
we
speak in the mic?
Hold the mic close there.
Okay. So I read.
Yeah, he can read it.
Yeah, okay, so, yeah, he prepared a few statements that, if I can go over and read. Good morning. I would like to say thank you for giving me the opportunity to explain my innocence that I had nothing to do with this business, so-called Royal Cigar. I never had a business in my life. On or about 2002 or 2003, BOE came to Armin's and Sophia's home, where I was a living roommate with them. When BOE came, they had no search warrant with them at that time. They took 5 boxes of cigarillos, and he wants to highlight that that's different from cigarettes. From Armin's room, and about 5 boxes of cigarillos from Armin's store, from a locked storage room. After doing my research, I find out that stamps were not required on cigarillos at that time. Today I'm going to talk about the 3 subjects. Please clear your mind so you will understand how BOE is trying to set me up. And we have 3 exhibits. I believe you have copies.
Yeah, one exhibited.
So the first one is about seller's permit application. You have a copy of the seller's permit application in front of you. Please look very carefully, and you will see they have redacted something and add Sahak's name and social security number, which is a forgery, so they can connect Sahak to this setup case.
This is the original.
I ask that you exclude this document as it is not my signature and should not be admitted as evidence.
That's second.
BOE again set me up by opening 3 systems, opening their system where they have access to seller's permit files where they added Sahak's name on January 1st, 2001, opened an account, and at the same day, January 1st, 2001, closed the account, connecting me to a Royal Cigar seller's permit. The copy that you see in front of you was picked up from BOE office in Glendale, California, showing opening and closing of that account. This document should also be excluded as it is not authentic and should not be in evidence, and it was manufactured by BOE to establish their case. The second exhibit, this is for the checks. BOE took original checks from the home where they entered without a search warrant. The court asked for the original checks. BOE said that they don't have the original and they lost it. They lied because if they showed the original checks, it would not show Sahak's name. A copy was presented to court where they put Sahak's name in front of the signature line to set Sahak up. Judge requested a subpoena from the bank asking for the signature card.
This is the judge.
And what a coincidence, the bank couldn't provide the signature card. Subpoena came back with no signature card in file and no connection to the account with Sahak's name. Once again, it's obvious just comparing check number 719 that somebody at BOE is trying to prove by any means necessary, even if it means doctoring the check. These checks are not authentic, they are copied and should not be entered for evidence. And for number 3, this is the testimony of Elena Chevaneva to BOE. It is very interesting that BOE believes that Elena Chevaneva is innocent even after giving false testimonies. Supporting documents are hereby provided for review. Yet when Mr. Jeiranian has always given consistent testimony, he has not or ever in any way, shape, or form owned a cigar store or a cigar permit. But the BOE chooses to believe Ms. Elena Chevaneva over Mr. Jeiranian in order to get false conviction for their own gain. I asked for BOE to provide me recorded interview. Instead, BOE provided me with another document which had 80% redaction to it and shows continuous inconsistency by Elena. Should you wish to find out the truth, you may do that by looking at the court documents instead of going on this wild goose chase. Couple of more things he has here. First one is BOE was saying that they took $40,000 from Armen and Sophia's home. When the court asked about the evidence of that $40,000, they said, we don't have it. Another lie because there was no $40,000. And BOE took 5 boxes of cigarillos from the house and took 5 boxes of cigarillos from the store. But BOE is saying that it was cigarettes and not cigarillos. Again, lying. Wanted to see the cigarillos to show that it's cigarillos, not cigarettes, but BOE said they don't have it. He was telling me just a little before that the importance of it being cigarillo and not a cigarette, that at the time, cigarillos were not required to have a stamp.
Because you research no stamp.
He's saying that he did the research and he found out that no stamp is required for cigarillos. He's saying that this case has been going on for 15 years already. And in closing, I ask that you look at all the evidence I have presented today, which clearly shows my innocence just by using common sense. When I was falsely arrested in December of 2007 and bail was set up for $583,000, and punished for something I didn't do. I completed 1,440 hours of graffiti removal. I was in an intensive outpatient program for 6 months, was evaluated by forensic psychiatry, had 5 years of probation, paid $20 to BOE every month for 6 years. I have been your space goat for many years. I demand you stop this intentional harassment and dismiss this case accordingly. Thank you.
Thank you very much. That's all I was going to say.
Okay.
Okay. This one is going already 15 years.
Okay. Thank you.
Madam Chair.
Department? Yes, Mr.
If I may.
Horn.
Madam Chair, given the request for translation and that the testimony was read in English, I think I would like to, as a courtesy to the taxpayer, somehow verify or attest that he understood what was read in English and he is prepared for us to proceed.
Yes.
Yes, he says he's.
Thank you, Madam Chair.
Okay. Thank you to the department. You'll have 10 minutes.
Sure. I think the interpreter might be here, actually.
He just said he understood what was
Yeah.
the English.
Okay.
I think it's fine for now.
So I can
okay?
just do
Yeah,
the normal. Okay.
just do it normal.
Thank you.
Although I would defer to him, Madam Chair, whatever he wants.
I spoke to the taxpayer outside, since
He's good?
he's good.
All right.
Great. Thank you. Chairwoman Ma, members of the board, I'm Pamela Mash from the board's legal department, along with Steve Smith and Jay Kefley representing staff. Taxpayer was the owner of Royal Cigar and is liable for the excise tax on the unreported distributions of cigarettes in California. Taxpayer has been criminally convicted of unlicensed distributions of cigarettes, possession of unstamped cigarettes, and possession of counterfeit tax stamps. Staff used the facts set forth in his criminal trial to conduct a civil audit, which led to taxpayers' liabilities here, over $743,000 in tax for the purchase and distribution of over 17 million untaxed cigarettes. The evidence in this case shows the taxpayer was the owner of Royal Cigar. The evidence consists of documents obtained from taxpayers' home and business pursuant to a search warrant, and includes cigarette purchase invoices from out-of-state suppliers, canceled checks with taxpayer's signature for the cigarette purchases, and delivery information showing that the cigarettes were delivered to taxpayer's home and business. Also found in taxpayer's home were almost 1,300 counterfeit tax stamps, 695 additional cartons of unstamped cigarettes, and falsified licenses and permits. Checks made out to Royal Cigar and the keys to the business were found in taxpayer's possession. And there are statements from his bookkeeper, an employee, and other witnesses who state that he was the owner of Royal Cigar. The evidence also shows the taxpayer held himself out as a licensed distributor to customers and cigarette suppliers by providing them with a counterfeit copy of a California cigarette distributor license and by affixing counterfeit tax stamps on cigarette packages. I'd like to just briefly address some of taxpayers' exhibits here. For the document marked Exhibit 1, those forms, I think one says original copy and one shows a BOE manufactured copy. The BOE manufactured copy is a form from 1996. If you see the very top of the form on the left-hand side, it shows the date that it was authorized. The form was 1/96. The second alleged original copy is 1097. So the original copy would have had to have been made a year after the copy we manufactured. I'm not sure how that's possible. Secondly, neither of those forms, they're not the same form. One is a seller's permit and the other is a license for a retailer. So they have nothing to do with each other. As far as the checks not being signed by the taxpayer, I have 4 boxes in my office and one giant box here under the table with all kinds of
original one?
Hold on. You'll have 5 minutes after.
with all kinds of checks signed by the taxpayer. He was the only person on that Bank of America account, and he was the only person who wrote checks for the business, for the rent for the business, for all the utilities for the business, for all the purchases of the cigarettes for the business. It's only his signature on every single check. And as far as the third exhibit with a statement from Ms. Alina Kivaneva, it's actually not really relevant to this case at all. It was a different case. So I'm not really sure what the purpose of that exhibit was. But ultimately, we have other testimony from taxpayer's own bookkeeper and an employee who say that he was the owner of the business. Not only is taxpayer liable for the tax, his conviction by a jury beyond a reasonable doubt, as well as the falsified licenses, the counterfeit tax stamps, and the unstamped cigarettes found in his possession overwhelmingly support the imposition of fraud penalties here as well. And for all these reasons, we concur with the Appeals Division's recommendations. Thank you.
Okay. Taxpayer, you have 5 minutes.
Just one question. Only one question.
He's asking if it's possible to show him one original check.
They have it, that original. Original check.
Yeah, if they have it,
Sure.
if it's possible to show.
We'd like to see
I
the
have
check
copies
too.
of all the checks. I don't have an actual check that he wrote. That wasn't provided to me.
No, they changed the original check with my name. They added my name. When I asked where is original checks, they said we lost it. Ask them if they have it. One original check, one only.
Okay, well.
They have millions of checks, right? Copy.
Yeah, I'd like to see
show me
what's
just
in your
one
box.
original check. I
Let me
really
show you the
appreciate it.
checks
Just
from
one
here.
original.
These are some checks, if you guys want to take a look.
That's a
Actually, let me
copy.
make sure I...
Presumably, the original checks go back to him, right? Checks.
And we have it from the bank. The judge requested. No connection at all on me and my name. Nothing. Right here. I have a judge order right here. Judge paper. This from judge. Not from me or somebody else. Just one original check. If you guys have it, I really appreciate it.
Madam Chair, we've got conversations going on that's not part of the record. If in fact the taxpayer wants this conversation to be part of the record, we would encourage that you utilize the interpreter and speak into the mic.
Okay.
Taxpayer requested the interpreters to step in. May I?
Sure.
Thank you.
I'm sorry.
That's okay. So please announce yourself.
Good morning, Nune Oganessian, Noune Court Certified Interpreter, Judicial Council ID number 301155.
Great. Thank you for joining us today.
Thank you.
Okay, so I need to swear you in, right? Ms. Richmond, do we have to swear her in?
You don't have to.
Okay. Do you want me to read the statement?
Yes.
Okay. Oganessian?
Yes.
Yes, Ms. Oganessian, you must use your best skills and judgment to interpret accurately without embellishing, omitting, or editing. When interpreting for Mr. Sahak, you must interpret everything that is said during the entire proceedings. Please do the same for statements made or questions asked by the board members or agency staff participating in this proceeding. Please interpret by speaking into the microphone when interpreting what the taxpayer says and speaking directly to the taxpayer when interpreting what all others are saying. If you have any questions or concerns during these proceedings, please do not hesitate to stop and address those questions directly to me as the chairwoman, and we will give you extra time to do the interpretation as needed.
Thank you.
Okay.
Very well.
Thank you. Okay, so I don't know. I mean, is this your signature, I guess? Can we verify? Because all those.
No.
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 Okay, so
I can present my license right now so that you can compare.
Okay.
And also, I am not able to read and write neither in Armenian nor in English. And they know it very well.
This is your signature?
Yeah.
I mean, we're not.
Okay, Mr. Horton, you want to start with the questions?
Well, just a statement, Madam Chair. Well, quick question. Well, statement.
And I request them to produce at least one original check because they have hidden the original checks and they are providing just the copies. They have erased the signature and put signature whatever they wanted, and they have added my name.
Okay.
Let them show at least one single original check.
Okay.
They have hundreds of copies, right? Let them show at least one original.
Very simple.
Very simple.
I'm not even going to question the department about their credibility in forging checks. It's no,
Thank you.
I mean, it's not in their best interest to do so. The exposure to them is quite significant in that regard. In particularly, thousands and thousands of checks.
Okay, so how do we start? Okay, I do have a question. Who is Sofia Simonian?
She used to be my roommate. We used to live together in one household. With her boyfriend, Armin.
Okay, so she filed this initial seller's permit or excise tax permit?
Seller's permit կամ excise tax permit.
Չեմ ֆայլների մեջից։
1996, it looks like the business started.
I don't know whether she had applied or no. I have no knowledge. I found it.
Ես մենակ ցույց եմ տալի, որ ես կապ չունեմ բիզնեսի հետ։
I'm just showing that I have no connection with the business.
Եվ ես կյանքից մեջ ոչ բանկի account ունեցել։
So did
And in my entire life, I have never had any bank account.
Ոչ էլ բիզնես եմ ունեցել։
And I have never owned any business.
So did Mr. Jeiranian, right? Jeiranian?
Yes.
Live at 5702 Lexington Avenue?
Lexington Avenue. Yes. And Sophia used to live here, and here I have a mail to show that up until present I received mail in her name.
Okay, so who owned, in Mr. Jeiranian's opinion, who owned Royal Cigars, Inc.?
Sophia and Armin. And they continue doing the same business up until present.
So this Exhibit 9, the one that...
They are sending cigarettes to Armenia. My apologies.
Okay, so the exhibit that he submitted that says made-up copy, did you fill that out?
No,
Who filled this out?
They gave it to me.
Board of Equalization
Board of Equalization had sent it to me by error. And the other one was sent to me as well.
But did he fill this out? Is this your handwriting? Your signature?
No. No. No, they made it up. I have never written it down, and my handwriting is not like that.
But your Social Security, is that your driver's license and Social Security?
Yes, they have added those. If you can look at the bottom, it's kind of crossed out or whited out, and my name was added. Let me find that paper.
Yes, sir. Very simple.
It's very simple. It shows.
Yes, sir. Okay. Yes, sir. Այս դեպքերս ջնջել են, գրել են վերևը, նորից կրկնում իրանք, ավելացրել են, էսի աստորագրությունները, էսի իրանք ավելացրել են։
Here it is, as you can see, it's been crossed out, and this one was added, pointing to the Social Security, and here, pointing to the signature. This was the signature, it was crossed out, this one was added, and the other writing was added too.
Հետո ստեղ որ կարտած ասած ասում որ էսի ռեկորդիկ եղած չի։ Նա այստեղ կապի է գրած, որ ասեք ռեկորդիկ եղած։ Իսկ ես ույս ռեկորդիկ եղած։
And if you could look at it, on the top it says this has not been recorded, and here it says copy only. And if you look at the second page, you can see that here it says recorded.
Original ACA.
This one is the original.
Well, it's not the original because they're different forms. They're different forms because the dates are different at the top. So if you look at the two forms, at the very top it says BOE 400, and they're different forms if you notice.
Yes, they made this up in order to make a connection of mine with the business.
Okay, well, whoever filled out the first one with Sophia's name, I mean, the signature is pretty similar in terms of all of the other filled in
Սոֆայի անունով ստորագրությունը շատ
live.
նման է մնացած լրացվածների հետ. Yes, they have simply added my name here in order to make a link between me and the business.
Okay,
In
so
the same manner, the computer was opened and my name was added and it was closed the same day.
Board of Equalization
And I got it from the Board of Equalization.
Okay.
Let me find that paper.
Okay, so to the department, who is Sophia Simonian?
She's someone who was employed by this taxpayer for a brief time, and it was alleged, and I can't prove that, and that's not part of this case, but it was alleged that he took her information and used it to apply for this permit. So, and I have to say, all of these.
Madam Chair, let me encourage the interpreter.
Oh, sorry.
Let me encourage the interpreter to speak into the mic and wait until after the testimony is done, so that the interpretation as well is on the record.
Oh, so he does not want simultaneous interpretation. So if you could wait till after she.
Very well. And the interpreter does not speak to the microphone, only.
No, speak into the mic when
only
interpreting.
when she speaks in Armenian, because it is my understanding that nobody else understands the Armenian. But I will switch definitely to consecutive and do it through the microphone. Very well.
I didn't quite get it, but I guess we're there.
So she's going to speak first, and then.
That's called consecutive interpretation.
Consecutive? Okay.
Does that mean that she's going to, excuse me, Madam Chair, does it mean that Ms. Barnes is going to have to speak and take a break?
Yes.
And give her an opportunity to
Yeah,
speak
so
into the
perhaps
mic?
you can speak, take
Sure.
a break, and then we'll have her.
Sure. So first, let me just take a step back and say that the documents that taxpayers presented here were also part of the criminal trial.
Can you pull the mic
Okay.
close to your mouth?
If you
so
could
that
talk,
we can-
yeah.
Thank you.
And I believe his defense at the time, which I think is what he's asserting here today, is that Sophia had taken his identity and opened up these permits in her name and his name.
Եվ իր պաշտպանությունը այն ժամանակ, ինչը որ հիմա ինքը փորձում է կատարել, նրանում էր կանոն, որ նա ուզում էր պնդել, որ Սոֆիան վերցրել էր իր ինֆորմացիան, որպեսզի իր ինֆորմացիան օգտագործելով ստանար պերմիտները։
However, what the
As
jury.
if I took it?
However, what the jury actually found based on these same documents was that he was the person who had filled out these forms. He was the person who had signed these checks. He was the person who was the owner of the business. No one else.
Բայց այս ներկայացած փաստաթղթերի հիման վրա ատենականները եզրակացության են եկել, որ ինքն էր այն մարդը, ով որ լրացրել է այս ֆորմերը, ինքն էր այն մարդը, որ ստորագրել էր, եւ ինքն էր այն մարդը, ով եղել է բիզնեսի տերը եւ իրենից բացի ուրիշ ոչ ոք։
Sophia has stated that she was his employee. For that reason, she had to fill out an employment application form, which listed her social security number, driver's license number, and personal information, and that he used that information to fill out these forms.
Սոֆիան ասաց, որ ինքը եղել է նրա գործավորը եւ աշխատանքի ընդունվելու համար ներկայացրել է դիմում, որտեղ ներկայացրել է իր social security համարը, իր driver license-ի համարը եւ անձնական տեղեկություններ, այսպիսով նա դրանք այդտեղից է ձեռք բերել։
And the court found that to be true.
Եվ դատարանը որոշել է, որ դա ճշմարիտ է։
And finally, if you look at the applications, the home address, the phone numbers, those belong to this taxpayer. Those don't belong to Sophia. They belong to him.
Եվ եթե նայեք հասցեն հեռախոսի համարը, այդ բոլոր տեղեկությունները պատկանում են այս հարկատուին եւ ոչ թե Սոֆիային։
Ես կարող եմ մի բան ասել։
May I say something?
Sure. Yeah. Yes.
Սոֆայի վկայությունը։ Սոֆայի վկայությունը։
Sophia's testimony?
Նմանա այս տեսակ վկայության։
Does it look like this?
Իրա ասա Էլինայի վկայության նմանա։
Does it look like Elena's testimony?
Որը որ փոխած մի քանի տեսակ։
Which has been changed on a couple of occasions.
Իրեք հատ տեսակավոր ցուցմունք ունի։
There are 3 types of statements.
Different
types.
Նմանա, Սոֆային սրա նմանա։
Is Sophia's statement something like this?
Thank you.
Okay, who is, I guess to the department, who is Elena Kevaneva?
Right. So, oh, sorry.
Հարցը ուղղվում է իրենց բաժնին, ով է Էլինե Քևանովան։
She's a cigarette business owner in a different case who knew this taxpayer, and she was interviewed at the time when they were executing search warrants on this taxpayer.
Ինքը ուրիշ սիգարետի բիզնեսի տեր է, ուրիշ գործով, եւ ինքը ճանաչում էր այս հարկատուին, երբ որ կատարվել էր այդ search warrant-ը եւ խոզարկությունը։
So, to the taxpayer, why is he submitting this memorandum of interview if Miss Elena, she owned Elena Cigars?
Եվ հարցը ուղղվում է ձեզ, այդ դեպքում ինչ եք ներկայացնում այս ցուցմունքները Տիկին Ալինայի տված, եթե ինքը ուրիշ բիզնեսի տեր էր, Ալինա սիգարի տերն էր։
Ես չգիտեմ, իրանք են ես ինձ ուղարկել։
I don't know, this was sent to me by them.
Իրանք են ես ինձ ուղարկել։
They sent it to me.
Առաջինը սա են ուղարկել։
This was the first one that was mailed to me.
Հետո երբ որ ես պահանջեցի,
and then when I requested,
այեսի ուղարկեցի։
They sent me this one.
Research արեցի։
I did a research.
Եվ ճիշտը գտա։
And I found the true one.
Բայց իրանք ջնջած են ուղարկել։
But they sent me the one that was covered up and erased. I hope you understand what is it that I'm trying to say. Should I say it directly?
Yeah, maybe I'd like to know why he's submitting these documents, Elena Cigars documents.
They were the ones who submitted it, not me. They wanted to set up this lady against me. To use her against me. If you could read, please, the third statement, and you can see. In this one, they're about to hang me, and in this one, I'm like the most innocent person. I look like an angel.
Okay. Does someone have any other questions?
I do.
Yeah.
Stowers.
I just wanted to respond
okay.
to the interview from Elena. We did not send this to the taxpayer on our own. He contacted our office multiple times asking for this. We went through our disclosure office because this is a different business, it's a different taxpayer, and there's confidential information on there. I'm sorry.
If the interpretation is consecutive,
sorry,
then I would ask to go one or two sentences at a time. Thank you. Ես ուզում եմ նախ եւ առաջ ասեմ, որ մենք չենք խնդրել, որպեսզի սա ուղարկվի, մենք չենք ուղարկել իրեն, այլ ինքը բազմաթիվ անգամներ զանգահարել է եւ պահանջել է, որպեսզի մենք սա ուղարկենք իրեն։
He asked so we had to go through our disclosure office because this is confidential information of a different taxpayer in a different business.
Եվ մենք պիտի գնայինք հատուկ disclosure ինֆորմացիան ստանայինք, որովհետեւ սա գաղտնի տեղեկություններ էր ուրիշ հարկատուի մասին եւ ուրիշ բիզնեսի վերաբերյալ։
So we had to go through the whole process of redacting it.
Եվ մենք ամբողջ process-ով պիտի անցնեինք եւ դրա մասերը հանեինք։
And after we sent it to him, he asked for a recorded copy of the interview, which does not exist.
Եվ երբ որ մենք դա իրեն ուղարկեցինք, ինքը խնդրեց, որպեսզի ինտերվյուի ձայնագրությունը մեզ ուղարկվի, եւ այդ ձայնագրությունը գոյություն չունի։
So it's very offensive for him to sit here and lie and say we forced this document on him. He harassed our office, he harassed the board proceedings office for weeks over this. And it's useless.
Շատ վիրավորական է, որ ինքը այսօր այստեղ նստած մեզ մեղադրում են անում, որ մենք ինքներս զորով այս փաստաթղթերը իրեն ենք ուղարկել, երբ որ ինքը անընդհատ նեղացնում էր կամ անհանգստացնում էր մեր օֆիսին եւ process անող օֆիսին այս փաստաթղթերը ստանալու համար, այսինքն սա ապարդյուն է։ May I respond?
Ես կարամ ռեկորդները հանեմ մեջտեղ, նորից սուտ են խոսում իրանք, ես կյանքում Board of Equalization չեմ զանգել, իրանք են ինձ զանգել։
I can retrieve the records, they are lying. I have never called Board of Equalization, they were the ones who called me.
ամեն անգամ։
Each and every time.
Եվ այս թուղթը իրանք օգտագործել են քորթում իմ դիմաց։
And they have used this paper in court against me.
This one right here.
This one.
Հետո մենք էսի find out արեցինք։
And afterwards, we found out about this one.
Էսի քորթում իրանք իմ դիմաց օգտագործել են, որ ես քեյսը կորցնեմ ասելով։
And they have used it against me in court so that I would lose the case.
Այդ 3 անգամ շահել են քեյսը։
But we have won the case only three times.
Եվ վերջի անգամ արդեն ասած, աջաջը up to here եղավ արդեն։
And last time the judge was up to here.
Այս քեյսը գնում է 15 տարի է։
This case is ongoing for 15 years.
Դրա համար ասա վրես մի հատ մի բան դրեցին ու get rid of it արեցին։
Therefore, they just put something and got rid of it.
Okay, can I ask the BOE staff, is there a Alina Cigars today?
Ուզում եմ հարցնեմ
I'm not sure if there's.
No. Ուզում եմ հարցնեմ Board of Equalization-ին, եթե այսօր գոյություն ունի Elena Cigars, ինքը պատասխանեց, որ վստահ չի։
I understand there's not.
Իմ հասկանալով ոչ։
So, this interview, it says that on July 15, 2005, BOE investigator Joe Novo and Franchise Tax Board Special Agent FTB David Valdivia interviewed Miss Alina Kavaneva concerning her business Alina Cigars.
Եվ այստեղ գրված է, որ հուլիս
Is this
15, 2015
true document?
2005 թվականին BOV-ին ինտերվյու արել Ալինային, Alina Cigars բիզնեսի հետ կապված, սա ճիշտ փաստաթուղթ է։
Yes, it was in 2005 when the criminal case was ongoing.
Այո, 2005 թիվն էր, երբ որ քրեական գործը ընթացքի մեջ էր։
Եվ ինքն էր նոր ասում էր, որ էսի սուտ է սարկած accuse եմ անում։
And she was telling that this is a lie, that this was made up, and I was accusing them.
Եվ սրա համար էր ասում ես։
And she was referring to this one.
Okay. Okay, Ms. Stowers, I may return. Let me look at more documents.
I think you,
Ես
the
ցանկանում
department,
եմ մի քիչ ավելի շատ փաստաթղթերի նայեմ եւ հնարավոր է վերադառնամ։
Խնդրում եմ ուղղակի ես։
Please, I just beg you.
Խնդրում եմ 15 տարի ա գոռում եմ։
It's been 15 years that I'm yelling.
15 տարի էլի պիտի գոռամ, որ ես մեղավոր չեմ։
And I will continue to yell for another 15 years saying that I'm not guilty.
thank you, I think I understand, but
Շնորհակալություն, ես կարծում եմ, որ ես հասկանում եմ։
I just want to be clear on the documents that we have one redacted version of the document, and it was sent to the petitioner because it was requested by someone, and because it did not involve his business, it was redacted to remove the confidential taxpayer information as required.
Ես ուզում եմ պարզաբանեմ առաջին փաստաթղթի վերաբերյալ, որտեղ ջնջված մասեր կան, ասացիք, որ այստեղ այս մասերը ջնջված են, որովհետև ինֆորմացիան վերաբերում էր ուրիշ հարկատուին եւ այդ հարկատուի գաղտնի տեղեկությունները ջնջված են եւ ինչ որ մեկի խնդրանքով սա ուղարկվել է ձեզ։
That's correct.
Ճիշտ է. And also, I want to be clear that when this interview took place in 2005, was there a business, Alina Cigars?
Ես ուզում եմ պարզաբանեմ, երբ որ այս հարցազրույցը տեղի ունեցավ 2005 թվականին, այդպիսի բիզնես գոյություն ուներ Alina Cigars.
Yes, Alina Cigars existed.
Այո, գոյություն ուներ Alina Cigars.
And then the statement made a few minutes ago was currently in 2016, does Alina Cigar exist?
Եվ երբ որ վերջում դուք ասացիք 2016 թվականին Alina Cigar գոյություն ունի?
It does not.
Thank you.
Շնորհակալություն.
We are talking about two different companies here, Alina Cigars and Royal Cigars.
Մենք խոսում ենք երկու տարբեր ընկերությունների մասին, Alina Cigars եւ Royal Cigars.
Correct.
Yes, correct.
Alina Cigar has nothing to do with Royal Cigar or the case at issue.
Ալինա սիգարը բոլորովին առնչություն չունի Royal Cigar-ի հետ եւ այն գործի հետ, որը հիմա քննարկվում է. In that case, why are they using this? Why were they using this? Why did they use it against me in court, and why did they continue using it up to present time against me? If I hadn't found this one, they would have been using this one against me. And I would have found 100% guilty in that case.
Okay. Thank you.
Thank you.
Thank you.
Ms. Harkey?
Տիկին Հակի,
Okay, thank you for coming.
շնորհակալություն, որ եկել եք.
I have read this report of interview.
Ես կարդացել եմ այս հարցազրույցի reportը. Yes.
The only thing that I see that it states is that Elena knew who you were.
Միակ բանը, որ տեսնում եմ, որ այստեղ գրված է, դա նա է, որ Էլինան գիտեր դուք ով եք,
And that you were a customer.
որ դուք հաճախորդ էիք,
And I don't see really any other connection.
եւ իրականում ուրիշ որևէ կապ չեմ տեսնում.
So I don't understand the point of bringing it forward, redacted or unredacted.
Դրա համար ես չեմ կարողանում գաղափարը հասկանամ, ինչու եք դուք սա մեջ վերում, անկախ նրանից, եթե ինչ-որ մասեր ջնջված են, թե ոչ.
Չի հասկանում?
Don't you understand?
Wow.
I want to hear you tell me why you're putting it forward. If this was part of a court case, it may very well be. We're not in a court case now. We're determining this issue.
Ես ուղղակի ուզում եմ, որպեսզի դուք ինձ բացատրեք նպատակը ինչու եք սա ներկայացնում, եթե սա դատական գործի մի մաս է եղել, շատ հնարավոր է, բայց հիմա մենք այստեղ դատական գործով չենք, այլ ուրիշ խնդրով ենք, ուզում եմ, որ դուք ինձ գաղափարը բացատրեք, ինչ նպատակով եք սա ցույց տալիս, ինչ եք ուզում ասած լինել։
Շատ բարձ, իրանք ուզում են, որ այդ մարդուն սերապանանի վրա, որ յանի այս բիզնեսը որ կայս Էլինային, ուզում են անենց անել, սերապանեն ին վրա հավատացնեն ձեզ, որ այդ բիզնեսը ամեն ինչը իմն է եղել։ Ես սրան օգտագործում են ավելի կարճ, սրան օգտագործելու են իրանք։
Because it shows that they were attempting to set up Elena against me in order to have her state that the business was mine, so that it will convince everybody that the business was mine.
This
is just to be used in order to make a connection between me and the business.
Okay.
The same way as
the
checks. Say, for example.
Okay.
We ask for the originals, and they're not producing even a single one.
Okay.
Because on the original, it has the correct signature, and it doesn't state Sahak. They have added Sahak. Let them present the originals. And they do have the originals.
Okay. Pardon me.
Let them produce at least one.
Excuse me. I'm not talking about checks.
Yes, checkերի մասին չեմ խոսում.
I'm talking about this that does nothing more than say that the woman in question knew who you were and described you. That's all it says. So it really doesn't matter for what we're hearing here.
Ես խոսում եմ միայն սրա մասին եւ միակ բանը, որ ես նամակը ասում է, դա նա է, որ տիկինը ձեզ ճանաչում էր, գիտեր դուք ով եք, եւ դա բացարձակապես առնչություն չունի այն հարցի հետ, որի առիթով մենք այսօր այստեղ ենք։
Okay, պատասխանում եմ հարցին։
Okay, let me answer your question.
Այս մեկին նայեք, խնդրում եմ։
Please look at this one.
Okay, I'm not asking any questions. I'm making a statement. So let's just stop now.
Ես հիմա հարցեր չեմ տալիս, ես ինքս խոսում եմ եւ խնդրում եմ, որ դուք հիմա կանգնեք սպասեք։
Okay, for the department.
Okay.
Thank you.
Շնորհակալություն.
For the department. it says here that taxpayer was the sole corporate officer of Royal Cigars, Inc., which was...
Հարցս դիմում եմ դիպարտմենտին, այստեղ գրված է, որ հարկատուն հանդիսանում էր Royal Cigars կորպորացիայի միակ օֆիցերը։
How did you verify that he was the sole corporate officer?
Ինչպես եք դուք պարզաբանել, որ ինքը միակ օֆիցերն էր այդ կորպորացիայի։
He was the only one listed on the Secretary of State's office.
Միայն իր անունն էր գրված Secretary of State-ի օֆիսում։ That's a lie. I have a paper here.
Okay, I'm not talking to the taxpayer now or the non-taxpayer. I am talking to the department. And this needs to be a proceeding that is handled back and forth.
Okay, sorry.
Thank you.
Շնորհակալ։
Okay. It says here that the department requested Department of Justice to execute search warrants in 3 locations. What were the 3 locations?
Այստեղ գրված է, որ ձեր բաժանմունքը խնդրել է Department of Justice-ին, որպեսզի խուզարկություններ կատարվեն 3 տարբեր վայրերում։ Խնդրում եմ ասեք, որոնք են այդ 3 տարբեր վայրերը։
They were the taxpayer's home, the taxpayer's business, and the home of Sophia Simonian.
Դա հարկատուի բիզնեսն էր, հարկատուի տունն էր եւ Սոֆիա Սիմոնյանի տունը։
Okay, I have here the search of the taxpayer's residence, so that is, I'm assuming, our taxpayer, our appellant.
Այստեղ գրված է, որ կատարվել է խուզարկություն հարկատուի բնակավայրում, ես մտածում եմ, որ ներկա գտնվող անձի բնակարանում է դա արվել։
Revealed 695 cartons of unstamped cigarettes.
Եվ գտել են 695 carton առանց շտամպի սիգարետներ։
Okay, this was not at the business?
Սա բիզնեսում չէր։
It was at the residence.
Դա տանն էր։
What happened to those when you discovered them?
Երբ որ դուք դրանք բացահայտեցիք, ինչ կատարվեց դրանց հետ։
They were seized along with the counterfeit tax stamps and the cash and everything else that was found.
Դրանք բռնագրավել են նաև կեղծ ստամպերի հետ եւ մնացած ամեն ինչի հետ, որ գտնվել էր։
The search of Miss Simonian's residence revealed what?
Absolutely nothing related to this business.
Ինչ էր ցույց տվել Տիկին Սիմոնյանի տան խուզարկությունը, բացարձակ ոչինչ այս բիզնեսի հետ առնչություն ունեցող։
I thought he lived with them.
Հարցնում է ասում է ինձ թվում էր, որ ինքը միասին էին ապրում։
Այո։
Yes.
Իր ամուսինն է տեղ ապրում, իր boyfriend-ի հետ է տեղ ապրում։
Her husband lives at that address. She used to live here together with her boyfriend.
With us.
With us.
Right.
It was 3 of us, me, Sophia, and her boyfriend.
Right. I'm talking now, and I didn't. I'm sorry. I read through that in the testimony.
Ես ցուցմունքների մեջ դա կարդացել եմ։ I'm sorry.
Okay. Thank you. I think that's it.
Շնորհակալություն, կարծում եմ այսքանն էր։ Thank you.
Anyone else? Okay. All right. Seeing no further comments from members.
Անդամները ուրիշ մեկնաբանություններ չունեն։
Is there a motion?
Որևէ դիմումագիր կա կամ միջնորդագիր։
I'll move for staff recommendation.
Second.
Ես ուզում եմ առաջարկություններ անեմ, մեկ վարքյան սպասեք։
Okay. Ms. Harkey moves for staff recommendation. Ms. Stowers seconds.
Ինչպեսի առաջարկություններ կան։
Without, what is that?
Without objection.
Without objection. Motion carries.
Առանց առարկության
Thank you.
միջնորդագիրը ընդունվել է։ Շնորհակալություն։ So what happened?
can explain.
Madam Chair?
Mr. Anjija, perhaps you can explain.
The board has, the board has voted to adopt staff's recommendation, effectively denying the petition.
այսինքն ձեր միջնորդագիրը մերժվում է եւ իրենք ուզում են ընդունել ինչ առաջարկություն, որ Board of Equalization-ի անդամները արել։ It was obvious. If you can't make a decision based on so much forgery.
I just have to leave a note. I have my note ready for it to go to get sent back to
Chairwoman.
So I think that concludes all of the matters for
Yes, it
today's
does.
agenda. The meeting of the Board of Equalization is hereby adjourned. Thank you very much for all coming.